Okay, so as Paula said, my world is I-864 enforcement. So 10 years ago, I was doing kind of standard family-based immigration law and started poking around into the law surrounding the Affidavit of Support and found interesting stuff. If you are like some of our colleagues, and I hope this will be disabused in the next 59 and a half minutes, if somebody comes into your office, and let's just say like a family-based adjustment or immigrant visa context, and this question comes up about the Affidavit of Support. At least as of a few years ago, a lot of our dear colleagues were advising folks something to the extent of, yeah, I've heard this is an enforceable contract, but, I've never actually seen it enforced. I want to disabuse you of that notion. Sorry, I've been involved in motion practice all day. I also would like you, if somebody like Anna comes into your office, to think differently about the following situation. So let's say Anna is a recent immigrant in the past year. She's on a 2-year CLPR status. Marriage is imploding, and she comes to you because she thinks that there's this thing called the I-751 that maybe it would be a good time to file, sometime in the next year. And you do a great job advising her about her potential grounds for an I-751 based on abuse, etc. What I would really like folks to consider proactively advising Anna about is her financial rights under the affidavit. Let's think about this like in a Padilla context, right? In the crimmigration world. Padilla says that if you're a criminal defense attorney, you can't just slough off advising your client who takes a criminal plea about the immigration consequences that come along with that, because it's a really big deal. I'm not pointing malpractice fingers at anybody, but what I'm suggesting is if somebody like Anna walks into your office and asks you for legal advice about an I-751, you might also want to tell her that she's got potentially valuable financial rights against her US petitioner, which might be a really big deal for her, because a lot of people in Anna's situation who are going through an I-751 petition in the context of a divorce are in really desperate financial circumstances, as we all know. And as we'll talk about in the next now 58 and a half minutes, somebody like Anna, if she's unemployed and contemplating an I-751, might have a really financially valuable case against her petitioner, and you might want to be telling her about it. Okay. Lots of stuff to go over here. I'm sorry Patrick can't join us, but he's too busy on his boat, probably enjoying a cold one without us. Patrick was going to be my co-presenter. We're going to go briefly over when the I-864 is required. Samira and Stephen already went into this, but there are a couple things I want to contextualize. We'll go through the parameters of a sponsor's duty. There are 3 duties under the Affidavit of Support. One of them is cool and interesting, the other 2 not so much. We'll talk about what these cases actually look like when the rubber hits the road from an enforcement standpoint, what you might be looking at if you're talking to a sponsor about potential defenses under this Affidavit of Support, because by the way, it's usually AILA members who get the phone call when a sponsor gets sued. So if you haven't dealt with a freaked out I-864 defendant, you probably will sometime in the foreseeable future. And we'll talk about whether Affidavit of Support rights are waivable. There's quite a lot of material to get through here, and I don't want to rush. If folks want to jump into the chat box with comments or questions, I'll answer all of them at the end of this or email you if we don't get to them. And open offer, I am always happy to talk about potential I-864 issues with any AILA members, so shoot me an email if you have a particular, very case-specific question you want to talk about. And I won't charge you. That's the big caveat. Okay, well, we all know why the Affidavit of Support is required, right? Because, and this has been actually the case since the very, very earliest days of federal immigration statutes and state-based immigration statutes, if you want to go back even further than that. It's always been the case that immigrants deemed likely to become a public charge were not admissible. So in 1996, Clinton era, American Online, great mid-90s days, a debate was happening in Congress on two major issues. We were largely revamping immigration law with what became IRA, and there was simultaneously a big remash of welfare laws in the United States in what became PWORA. Why does this matter? One of the things that happened in the welfare debate was that
Greg, you're muted.
Have I been muted this entire time?
No.
Okay. I didn't press anything, so Paula must have had enough. Okay, so 96, two big policy debates, welfare and immigration. The Republican legislature took away means-tested benefits from recent immigrants, those here as residents for fewer than 5 years. And we were also taking a hard look at immigration law. So a policy decision that was taken by Congress, you don't have to like it or agree with it, but this is indisputably what happened, is that at the same time the public benefits were taken away from recent immigrants, a new legally enforceable obligation was put on the shoulders of immigration petitioners. So the policy idea is we, taxpayers of the United States, are not going to be the financial safety net for recent immigrants, and instead, those petitioners who elect to bring family-based immigrants into the United States are going to be faced with a new financial burden of being that financial safety net for those recent immigrants. So when you look at the legislative history of PWORA and IRA and the cases that interpret that in the context of the Affidavit of Support, they take a very clear view that the policy decision that Congress said was, we want to prevent recent immigrants from becoming public charges, i.e. dependent on US taxpayers. And to prevent that from happening, we are going to put this new financial duty on immigration petitioners. And we'll talk about the parameters of that in the following slides. As our co-presenters have already talked about, functionally, the Affidavit of Support is required in all family-sponsored cases. Yeah, there are exceptions, primarily for folks who have extensive work history in the United States, but really, I mean, if you talk to somebody who came to the US on a family-sponsored visa or adjusted, there's a very, very high chance that the Affidavit of Support was executed. Let me do a quick skim through questions to see if there's anything we need to talk about right now. We'll talk about stats later in terms of the number of suits that have come up. Okay, so the Affidavit of Support, these three propositions I submit to you are totally undisputed propositions of black letter law at this point of time. It is a contract between the sponsor and the United States government. The whole reason that Congress got its fingers into this was recognizing that the I-134, which predates the current Affidavit of Support by a long time, was unenforceable. So the whole reason they were creating what became the Affidavit of Support was to create a binding, legally enforceable contract. Who can enforce it? The beneficiary is named as a third-party beneficiary of the contract. So I know many of us haven't thought about or wanted to think about contracts since first year of law school or maybe the bar exam, but remember, usually somebody who's not a party to a contract can't walk into court and enforce it. Third-party beneficiaries are the exception. So the sponsored immigrant has legal standing to sue. It's right there in the statute and it's in the contract itself. And finally, the Affidavit of Support is enforceable. So no court, nowhere in the US holds to the contrary. Find a case and I will buy you dinner. Every state decision to look at this, every federal, district, and circuit level decision says the Affidavit of Support is enforceable, to the extent that I think you would run into a frivolity argument if you actually tried to defend a lawsuit on the basis of it not being enforceable. So fun fact, thinking about this as a contract, the sponsor is incurring some pretty significant obligations that we'll talk about. What do they get in return? Because remember, enforceable contracts require consideration on both sides. And the answer is that the government says, your intending immigrant family member ain't getting through the door unless you sign this affidavit of support contract. So remember, from 1L year, consideration can be practically anything that's of value to the promisor. And in this case, yeah, the guy probably wants his wife, his mom, his kid to be able to immigrate. And so that thing of value, getting past public charge inadmissibility, is the reverse consideration. And every court that's considered this issue has said, yeah, that is enforceable. That is adequate consideration to create an enforceable contract. As a side note, remember that the Congress has plenary authority in the field of immigration, right? This is Congress operating at the height of its power. So even if the four corners of the contract weren't enforceable under standard contract law provision, Congress can do virtually whatever it wants in the field of immigration. So if Congress says this document, is an enforceable contract in the immigration context, that's probably sufficient to create something that's enforceable against the sponsor, even if it's a banana peel that's signed with mayonnaise. If Congress says it's enforceable, it is in the immigration context. Okay, lots of folks get hung up on the first of three duties imposed on the sponsor, and that's this duty to repay means-tested benefits. This thing totally blew up under the Trump administration, under those draconian public charge rules that were put into place and then taken away months later. On paper, the sponsor has an obligation to repay any federally funded means-tested benefits that are paid to the immigrant beneficiary. Yes, you should be advising sponsors that this is a thing. Yes, you should be aware of it. To my knowledge, there has been one instance where this was enforced in the past half decade. Dan Kowalski, who's the editor of Benders, was involved peripherally in one case in Colorado. To my knowledge, there is no jurisdiction anywhere in the United States that does this on a systemic or even occasional basis. For example, here in Washington State, where I happily reside, the agency doesn't even have a policy or procedure for how they would do this. So the local Health and Human Services agency, if you went to their legal department and you said, hey, we're going to go get the sponsor for some Medicaid benefits that were paid to an immigrant, they would look at you like, we don't even know how to do this. So in the real world, this just doesn't happen. Third duty is sponsor, of course, has to update USCIS about a change of address. There's a civil penalty for not doing this. That's another case where I have never heard of that actually being enforced. If you have, I'd be super interested in hearing about it. Why does the sponsor have a special obligation to update address? It's because of the other duty. So the government wants to be able to track the sponsor down if they need to for enforcement purposes. But this is the fun one. Sorry, I'm just trying to get my clock here so that I don't go too long. So this is what we're focusing on, the third duty. This one is very much real, and this one very much does get enforced. Duty number 2 is to maintain the immigrant's income at 125% of the federal poverty guideline. That changes every year. We're all pretty familiar with it if we do family-based cases, because we're trying to get our sponsors past that safe harbor income level for being sponsors. But it works out to be roughly $1,300 per month. That's important in my world because that's what an immigrant beneficiary can potentially recover under the I-864 contract. We'll talk about damages calculation on a little bit more granular basis. But in short, when you are the immigrant beneficiary, unemployed, and looking to a sponsor for potential financial support or damages in litigation, what you can recover is 125% of the federal poverty guideline for your household size. And just to foreshadow a little bit, since we are all in the Ninth Circuit or practice in the Ninth Circuit, household size for damages calculation means those immigrants who were sponsored by an affidavit of support. So if you have mom who came over on a K-1 and had a child who followed her on a derivative K-2, Those are both household members. However, mom's second and third kids from who, let's say, were born after they got here, are not household members. Basically, in the earlier case in 2015, the Ninth Circuit said it's fair for the sponsor to basically be on notice about what his or her obligation is under the Affidavit of Support. And so we're going to limit household size to the people the sponsor knew that they were sponsoring and not put them on the hook for afterborn children, as the case might be. How long does the Affidavit of Support last? So 5 and only 5 events end the sponsor's obligation. 3 of these are set forth in the INA itself. The other 2 were added as interpretive gloss in the implementing regulations. Number 1, it ends when the foreign national becomes a US citizen, not when they apply for it. So sometimes we'll have a case where somebody has filed an N-400 and then realizes they want to sue their sponsor. And so we'll say, whoa, withdraw your N-400 or hold it in abeyance for a while. When the person has been credited, the immigrant has been credited with 40 quarters of work, not earned. So the INA defers to the Social Security Act on this because under the Social Security Act, spouse 1 can be credited with quarters of work that are earned by spouse number 2 during a marriage. And this is a very, very common type of argument for us to have in litigation, where my client might have been unemployed throughout the marriage, and sponsor wants to argue about how many quarters of work my client has, having been imputed those quarters of work from the other spouse who was working. Number 3, the affidavit terminates when the person loses residency. It doesn't have to be abandonment. It could also be lost in removal proceedings and departs the United States. So notice that merely losing residency doesn't end the obligation. So you could have somebody who's sitting in detention with a final order of removal. If they haven't left US soil, they still have rights under the Affidavit of Support contract. Conversely, and this certainly happens, you can have somebody who hasn't lost residency, but has left the United States. This came up in a preliminary injunction hearing in a case in the Northern District of Texas just a few weeks ago, where my client had been abroad actually for more than a year. And the judge, who obviously had some immigration background, said, wait, don't you lose residency or something? And we had to say, no, judge, there actually has to be a procedure that's through which residency is lost. It's not lost by operation of law. So even though the person had been gone from the United States for a long time, had managed to re-enter on their CLPR status, the I-864 was still enforceable. Number 4, I've never seen if somebody is ordered removed, but not ordered removed. If somebody in removal proceedings readjusts through a new petitioner in removal proceedings with a new I-864, that new affidavit of support replaces the old one. I've never seen this. And finally, my clients tend to be alive, so the contract terminates when somebody's dead. You're not likely to see that. What we really see as the ending events for the Affidavit of Support are either the immigrant becoming a citizen or getting credited with 40 quarters of work. That's realistically the end point for this sort of thing. Quick scan of questions. Okay, so if the sponsor, whether a primary or joint sponsor, relies on the intending immigrant's income, the sponsor's duties are the same. So, and that's true also if you have a sponsor who's unemployed and they have to bring in a joint sponsor. It doesn't matter. Once you sign the affidavit of support and it's filed in support of the immigrant visa or adjustment case, it is by operation of law deemed executed and enforceable. So notice what does not end the Affidavit of Support contract. Dissolution does not end it. And the vast, not all, but the vast majority of enforcement cases are disillusioned spouse or disillusioned soon-to-be ex-spouse going after their former spouse petitioner. Remarriage doesn't end the obligation either. So you can have, and there are cases where former wife remarries, happily going on with her life, and goes back and sues the sponsor because she's unemployed and qualifies for support. And that, let me tell you, is not a happy sponsor. Just to flag them, we won't do a deep dive into this. Some of the issues that remain relatively unresolved in the case law around these is on the issue of how you credit quarters of work. What do we do if there's been a long period when the couple was married and then there's a divorce? Well, if you're the sponsor, you want to argue that all of the quarters of work from both spouses are credited from the marriage. And unfortunately for that argument, that's not how the Social Security Act is written. Both the SSA and the INA are clear that the crediting happens only so long as the couple remain married. So once the marriage ends, then all of those quarters from the US citizen spouse are no longer credited. But there aren't a lot of cases that are clear on that. An issue that often leads, it's almost one of the only issues that leads to discovery in these cases, is unreported income, which we chatted about a little bit in the last presentation. But it's really common for folks to be doing irregular work that doesn't show up in their tax returns and then their Social Security records. So if you're the sponsor, you want to go on a fishing expedition and discovery to figure out if the person has unreported income. And lastly, sponsors get really mad about paying support for periods of time when a client of mine is outside of the United States. So somebody's gone back to visit family in India for a year, and they want to recoup damages for that period of time. Unfortunately for the sponsor, there's really no toehold in the INA or the Affidavit of Support that distinguishes where the sponsored immigrant is. So from a policy perspective, it might have made sense for Congress to differentiate between where the sponsored immigrant is, but that distinction just isn't made in the law. So the bottom line is you as the intending immigrant can recover support for the whole period of sponsorship, regardless of where you are. Oh yeah, and when you have non-immigration lawyers who are defending these cases, which is often, they get really excited because they say, oh, your guy was a conditional permanent resident. And when they transition to unconditional LPR status, that was an adjustment of status or a change of status. First of all, it's not either of those things. But secondly, that just doesn't matter. Recall that the terminating event is losing residency in the United States and departing. So first of all, going from CLPR to LPR status isn't changing from one residential status to another. There's only one under the INA. One has a conditional status attached to it, the other doesn't. Bottom line is going from CLPR to LPR doesn't change anything in terms of your rights under the affidavit. And that is so clear that it would be frivolous as a defendant to argue that. And we have had them withdraw the argument on that ground. Does the I-864 naturally end at the event of the above reasons? So in terms of those 5 terminating events, by operation of law, that terminates the affidavit of support. Now, you still have to argue that in court, right? So if we have a disagreement about whether there are 40 quarters of work, there's no magic place to go to and prove whether or not that's happened. But it's a legal event that obtains, for example, upon the person's death, that by operation of law ends the affidavit of support. May an LPR with a re-entry permit sue under the I-864? Sure. Why not? Okay. Where does this actually happen? How often does it happen? And so forth. By my count, there have been roughly 150 or so federal district level cases on this. That's almost certainly uninclusive because obviously there's no way to search PACER to find every case that mentions the affidavit of support. But using all of the search tools like Docket Alarm and so forth that do try to peek into PACER, that's basically what I come up with. Fun fact about that, by my last analysis, 56% of these cases involve pro se defendants, or sorry, pro se plaintiffs, which is actually not so unusual. That's relatively common for the norm in civil litigation. But what that means is that of these 150 cases, about half of them, the judge is trying her best to figure out how to rule on motions when you've got a non-native English speaker providing a brief, doing their best job. But some of the cases ignore binding regulatory provisions that pertain to affidavit of support enforcement. And I think the reason is that the judge just never heard about it because a pro se plaintiff and maybe a pro se defendant just never told them the important things the judge needed to hear. And I don't have stats for state court cases, but it's somewhere in that vicinity would be my guess. One thing, so I do a lot of talking about this to family law attorneys, and something I hear from family law attorneys and the family law bench is this is a federal issue, so it belongs in federal court. I'm afraid that speaks to a fundamental misunderstanding of our court system, because under procedural doctrine called the presumption of concurrency, if a federal statute creates an enforceable cause of action, by default, that can be brought in a state court of general jurisdiction. So think about civil actions under Section 1983. That's federal or state, even though the federal statute creates the cause of action. The only time that federal statutes can't be enforced in state court is if Congress takes it away and says, no, this is an exclusively federal matter. And there's nothing like that that could even arguably be interpreted in that way. Marriage of Kumar settled this in California. Well, Marriage of Kumar, I was on the appellate panel prepping for that, stands primarily for the proposition that you can enforce the affidavit of support in family law court, which we'll talk about in a minute. But yeah, it does speak in a sense to the concurrency issue. So aside from the presumption of concurrency, like this is also just a contract. Like forget about the federal statute. Just pretend it doesn't exist. It's a contract. So contract can be enforced in any state court of general jurisdiction, including small claims court. So there's not a lot of money at issue in these cases sometimes. If you don't want to go into a big state court, maybe just go into small claims court. Question about the duty to mitigate. One of my favorites, and we will get there shortly. So within the Ninth Circuit, there's absolutely no question that federal court has jurisdiction in these cases. There's a statutory provision right there in the INA. It's at 8 USC 1183A E1, and it says beneficiaries can sue to enforce the contract. So every federal court in the United States that looks at that says, well, there's a federal statute that says go sue. That sure looks like a federal question cause of action to us. Two courts have held to the contrary. One is in the Middle District of Florida, the other's in Colorado. These were both magistrate decisions. I think at this point, it's safe to say that those are both enigma isn't the right word, aberrations. So after that Middle District case came down, there was a recent decision, the Grainer decision in the North District of Florida, that was basically like, that's the craziest thing we've ever heard. There's a federal provision and right in the statute. So you don't have to worry about Florida because you're in California. The bottom line is in the Ninth Circuit, there's no question that there's federal question jurisdiction in these cases. But again, state court, it's just a contract. So there is no question at all that a state court of general jurisdiction can enforce one of these contracts. Now you'll have a confused judge, that's for sure. The judge will not have seen one of these cases, but that being the case, from a jurisdictional standpoint, there's no question you can go to state court. And to answer the question that just came up, yes, joint sponsors get sued. And those are the cases that have the highest likelihood of getting settled, because as you might imagine, when petitioner gets sued and then petitioner's dad, who was the joint sponsor, gets sued, suddenly there's a lot of pressure on primary sponsor to get his act together and comply with that contract. So joint sponsor cases are good from a plaintiff's perspective. Sorry, the timing here got all messed up in terms of the transitions, but in a dissolution context. So recall that these are typically cases where dissolution spouse 1 is suing dissolution spouse 2. So it's very often that it's while a divorce is pending that this first comes up. California is one of several cases, and the marriage of Kumar case, which was mentioned by Craig Rice, absolutely squarely 100% stands for the proposition that A, you can enforce the affidavit of support in a dissolution case in California, yay. And number 2, you can do so via an alimony order. The reason that is particularly significant is that there are fun enforcement mechanisms for alimony orders that don't exist for standard civil judgments. So this is great news for plaintiffs in the state of California. Same is true in North Carolina and Texas. In outlier, and I will confess that I represented this appellee in the state of Washington, you do have to bring a standalone cause of action. So albeit that, let's take cases, states like California and North Carolina, where you can enforce this in the context of a dissolution proceeding. As appealing as that sounds, one of the problems is that if you bring one of these things in federal court, the judge is going to be focused on what's in the affidavit of support contract, the implementing regulations, and the INA exclusively. And those are all things that you like if you're a plaintiff. It's, in a sense, a very cut and dried cause of action, 125% of the poverty guideline. You get that until the contract terminates. Pretty clean cut. Once you get into a dissolution proceeding, all of a sudden, there's all of this stuff about multi-factor considerations that go into considering alimony orders. These generalized notions of equity come into play, and things get really muddy. And what you end up seeing, and this happens all over the place, I can think of a couple cases in Texas where the judge says, yeah, I get it, the affidavit of support is enforceable, but looking through this like equity lens, well, it seems fair to limit support to 3 years or 2 years or 6 months. So that sucks if you're an I-864 plaintiff, and you are much better being in federal court where the judge will say, all right, well, this is in effect until the contract terminates. So there we have it. Typically much better results for I-864 plaintiffs in federal court, standalone civil action. Damages, what do you get? So the basic measure is clear. Recall that the obligation is 125% of the poverty guideline. So your damages equal whatever that is, 101,342 currently, minus any actual income. So the easiest cases are where you have an unemployed plaintiff. That's just 1,342 minus 0 per month, right? So if you've got 6 months at 1,324, those are what your damages look like for the 6-month window. So make no mistake, like nobody is getting rich off of this. Sometimes in the social medias, I will be barraged by right-wingers who are just outraged that there are immigrants getting rich off of the back of hardworking American sponsors. Well, first of all, it was an idea of the Republican Congress to put this thing into effect, so don't come crying back to me over it. But secondly, you're not making that much over these things, right? 125% of the poverty guideline. Are you kidding me? Like we're talking about like the very bare minimum amount that it takes for somebody to survive. And frankly, in New York or San Francisco, you're not surviving off of $1,300 per month. That's editorial anyway. So in addition, you can of course get an order, well, not of course, but I will share with you that you can get an order of specific performance from courts typically. So the judge will say, okay, damages are $7,000 to date, and also you, petitioner sponsor, need to be complying with this obligation on an ongoing basis. Okay, now things get a little bit complicated. So 125% of the poverty guideline minus income. Well, what's income? This is one of those areas where courts have, where the case law is a bit confused. And it is my best guess that the reason it's confused is in large part due to pro se litigants. So the way that you will see some courts tackle this issue is through this kind of what I think of as the crystal ball of equity, which is my least favorite of all crystal balls. So, I mean, of course, if you've got a plaintiff who's not dead, they are living off of something, right? Unless if they are eating food and they have a place to stay, that's coming from somewhere. So you have things like somebody is giving them a place to stay free of charge. There are cases out there that say, if that's the case, we will take the fair market rental value of that place and impute that as earned income to the immigrant. There are even cases that say we will impute the value of food stamps that the person is getting. All of this is done in these decisions without any particular reference to what legal standard actually governs this issue. It just seems sort of fair, in some sort of sense. It's not really typically the way law works, right? Typically, we try to ascertain the legal rule that applies to a particular situation and apply that legal rule. And guess what? There is such a rule contained directly in the implementing regulations. So 8 CFR 213A1, this is the definitional section, has a really clear definition of income, and that applies throughout the part. So this definition of income pertains to all of the regulations governing the Affidavit of Support. And it says income means that which is subject to federal income tax. Well, that seems sort of fair, because the whole purpose, in a sense, of income rules are to ascertain, like, well, what is income in the sense that it's earned income and something that should be subject to federal income tax. And by the plain reading of the federal regs, or the then INS just imported that definition and said, okay, well, we are going to count as income whatever the IRS says taxable income is. So that would make it really easy. When it comes to calculating damages, X dollars count as income for purposes of offsetting the sponsor's obligation only if it's subject to federal income tax. So that gives you easy answers to the categories raised above. If Bob gives my client a couch to crash on because my client is homeless and broke, that's not income because it's not subject to federal income tax. If my client gets $10 from his friend to buy some groceries for the week, that's also not subject to federal income tax. So there is an easy answer out there. It hasn't been clearly established in case law yet. Sneak preview, we are just about to file a case in Pennsylvania, which will have Van Duan on the other side. She's the best immigration defense expert out there for sponsors. She's out of Maryland, also an AILA member. And we're going to go toe-to-toe directly on this issue. So whether I win or lose, we will at least have one clear district court case on this in the foreseeable future. Let me pause for, I'll pause before the next section. Okay, so in addition to damages, the statute, regulations, and contract are all very clear that the beneficiary may recover costs and fees incurred in the course of enforcing this. Here are some numbers. One of the things you will notice is that these fees tend to be a lot more than what you might expect a beneficiary to be able to recover under the Affidavit of Support, which is exactly probably why Congress put a fee shifting provision in there to begin with. So if you have claims that are worth, $1,300, let's say you're only going after 1 month of support, well, you could never pay an attorney to enforce that obligation, because as soon as the person gets done completing their intake file, they will have racked up more fees than you're ever going to recover in damages. So Congress, I think, recognized this and said, well, sorry, sponsors, if you flake out on your support obligation and you make a defendant or make a plaintiff go through the paces of enforcing this, that was a bad decision and you were going to be on the hook. And courts have been very consistent about honoring that attorney fee provision. It's something, I had one magistrate judge in Maryland equate this to Fair Labor Standard Act litigation. That's another context where oftentimes the attorney fees greatly exceed the principal liability. But again, as with the I-864 context, your rights to enforce wage regulations would be worthless if the defending employers of the world could just swamp you with litigation and make it too expensive to litigate them. So one of the takeaways from this is that if you do end up talking to one of these sponsors, you know, in the vast majority of cases, it is greatly in the sponsor's financial interest to work out an amicable resolution of these early on. Because if you fight this even, even just by ignoring the litigation and letting it go to default judgment, as in the Fakita litigation here, this was almost $20,000 in fees that the person just shouldn't have had to pay if they just lived up to their obligation to begin with. Somebody asked about failure to mitigate as a defense. Good question. So what defenses are available to Affidavit of Support sponsors? Well, historically, courts have assumed without argument that standard contract law defenses could potentially apply. I say potentially because some of the cases that address these, oftentimes this is on summary judgment, they will go into the alleged facts of the affirmative defense. So fraud in the inducement is like the favorite one of sponsors. I call it the she never loved me defense, because usually you have a situation where, marriage falls apart. And so the defense from the sponsor is, she never loved me. She married me for a green card. She was planning this all along. The whole immigration thing was just a ruse to get a green card, blah, 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 blah. So historically, some of the courts have at least gone through the practice, gone through the paces of looking at this on a summary judgment basis and said, oh, come on, just being pissed off at your ex is not grounds to say that you were fraudulently induced into signing a contract. So even when this was raised, it died an early death. Other defenses like illusory contract, remember this is the issue of what does the sponsor get as return consideration for the Affidavit of Support. These have been tossed out on the grounds that the thing you got is the thing you asked for, which was your spouse's immigration. Sorry if you have buyer's remorse now, but that doesn't make the contract illusory. And unconscionability, basically the argument is like, oh, yeah, I wanted my wife to immigrate, but not that badly. this turned out to be too expensive. And the response is tough luck. That, yeah, it's a pretty serious financial obligation, but it's one that you elected to bring upon yourself. So that's historically. In the Ninth Circuit, it's a different story these days. I owe a lot of this to my former colleague, Jody Winters, who litigated these cases in California with me. Long story short, we now have a long string of cases in California and Washington with no contrary authority, which hold that affirmative defenses categorically do not apply in Affidavit of Support cases. So things like, all of these things, and also the duty to mitigate. As a primer from folks, again, who haven't thought about this since 1L, the duty to mitigate is a standard common law doctrine that says a contract party has an affirmative duty to mitigate damages if they can. What that means in this context is that a sponsored immigrant would normally have an obligation to seek gainful employment if they could. It's sort of like the idea of imputed income in the alimony context. The Seventh Circuit in Leo v. Mund, Judge Posner, if anybody's heard of him, said categorically that just doesn't apply. The reasoning in Leo v. Mund, and this is the reasoning that's been adopted within the Ninth Circuit, is Congress told us when a sponsor can get off the hook for their liability. What are those conditions? It's those 5 terminating events under the affidavit. So, sponsor, you're coming to us and you're saying, I don't really want to pay down my responsibility on this contract because I think my former wife could be employed even though she's not actually. And Judge Posner says, sorry, that's not the way it works. You are on the hook for support until the contract terminates, and this counterfactual fiction of whether your wife is voluntarily unemployed just doesn't matter. And that reasoning in the Ninth Circuit has been expanded to embrace all affirmative defenses. So fraud in the inducement, forget what facts you have. It just doesn't matter. Even if, former spouse writes the email, ha ha ha, this was just for immigration purposes all along. It doesn't matter. It doesn't change the obligations under the contract. All of this was recently upheld in a case litigated by my buddy Ross Kinder in the 11th Circuit. So it's now been upheld on a circuit level recently in the Belovich litigation. And Belovich, it might be worth mentioning, was a case that involved like the absolute least sympathetic plaintiff of all time, who did horrible things. And nonetheless, the 11th Circuit still said no affirmative defenses available to affidavit of support sponsors. So in the Ninth Circuit, no defenses, sorry. Let me look at questions real quick. Oh yeah, sorry, I took this slide out. For Darren Yun, he asks, can this be discharged in bankruptcy? There's not a lot of case law in this, only 2 cases that I'm aware of out of Florida, and both of them hold that the I-864 liability is a non-dischargeable domestic support obligation. Stephen's like, what? Because it's like alimony. I mean, the idea is that this, again, primarily this is in a marital context. This is something that's one spouse sponsoring and providing basic financial support for the other spouse. And so I can't rattle off the exact definition of a DSO, but the bankruptcy court didn't have any problem finding this to be a non-dischargeable DSO. Okay, some of these are a little bit too lengthy for me to get into. In terms of asking the plaintiff what efforts they've made to obtain employment, it just wouldn't matter in the Ninth Circuit. So the defendant could just tell you, I don't want to work. And in the Ninth Circuit, that wouldn't matter for purposes of their damages under the contract. So prior to Erler, I'm sorry, I said that was in 15, it was actually in 16. We had one district court case in Hawaii where a magistrate in dicta seemed to say that affidavit of support rights could be waived in a nuptial agreement. Well, that would be fun if you're an affidavit of support sponsor, right? Because you would just, your spouse is at the consular stage, you fire off your affidavit of support to the National Visa Center, and the next day you execute a nuptial agreement with your spouse and you say, ha ha ha, you know that thing that we just told the State Department about supporting you? Let's not do that. So earlier, the Ninth Circuit was not thrilled with that sort of approach and said, no, look, the purpose of this from a congressional policy standpoint is, again, to ensure actual financial support for the sponsored immigrant. Well, that's totally undermined if the sponsor can do exactly what I was just suggesting. And on the one hand, tell the government, I got this, I'm taking on the sponsorship obligation that you want. And then the next day, in a private agreement with their wife, just tear up every obligation under the I-864. So settled within the Ninth Circuit, no, you can't do that. Antinuptial, postnuptial, it doesn't matter. And even in a final order in a dissolution divorce case, can't waive affidavit of support liability. So at least on my reading of Erler, if we're talking about claim or issue preclusion, the idea that you can screw up your affidavit of support rights in a family law proceeding isn't supposed to be able to happen within the Ninth Circuit. Now, I'm a lawyer and I'm cautious, you're lawyers and you're cautious, so you wouldn't want to try to screw up affidavit of support rights in a family law proceeding. But if you have somebody who comes to you, they've already been divorced, you shouldn't have to worry about the possibility that they've quashed their affidavit of support rights by virtue of failing to raise them in a dissolution context. Good news for plaintiffs of the world. Okay, what actually happens with these cases? Well, as any judge would tell you, of course, the majority of civil claims of all varieties settle, and this is no exception. I should really do a scatter plot of like how long my cases actually take to settle, but the short story is that you've got a small percentage of cases where the sponsor gets their demand letter and says, "Oh my goodness, I legitimately didn't know that I had this obligation. I'm sorry, let me pay up." I think I've had 2 of those ever. Usually what happens is that the sponsor gets the demand letter and says, "Yeah, I bet I don't really have to deal with this." And so the federal complaint gets filed. Often that's when they lawyer up. And if they get a good lawyer, that's when settlement negotiations get real. I am sorry to report that many of our colleagues within the AILA community and also the general litigation bar seem legitimately to think that they're going to get their sponsor client out from under this if they just make it painful enough for the plaintiff or spend enough money on discovery to get I don't know what. But some of these cases do make it pretty far into litigation. We even had one, and this is the only one ever that I've had, go to a federal jury trial in the Central District of California, where the defendant promptly lost. So after it was almost I think it was almost 3 years of litigation, they had a team of attorneys on their side. We had a team of attorneys on our side. The fees were like $200,000 or something by the end, and they got their federal jury trial. And all that came of that was the jury said, well, yeah, the contract is enforceable and you didn't pay and you got to do that. So anyway, most of these do end up settling. It's just a matter of when. And sometimes that's after a little bit of discovery. So the sponsor has the obligation to probe primarily what the person's income has been. Because aside from that, the facts aren't in dispute. I mean, we'll fire off a FOIA request as soon as we get the file. So we've got the affidavit of support. You can't deny that you signed it. The person has their residency or they don't. They do. Here's their green card. So there's really very little to fight over. In terms of how settlement is structured, usually the obligation is not really all that high. Sometimes you'll just have the whole thing paid off in a lump sum amount, but more often you get a structured sort of settlement where the parties set a number for here, we're just going to pick a number and say that's this total settlement of all claims under the affidavit of support, and we'll pay it off at $5,000 a month until it's gone. Then everybody goes on their way and it's fine. The other way that these get settled is that there is a sum certain that is owed so far because we can calculate the damages, but the contract obligation is going on into the future, right? So in those cases, one way you can approach it is to say, well, we'll just check in every month If my client's unemployed, you'll cut us a check. If she's managed to be employed, then you're off the hook for that month. That sounds really good until you think about attorneys on both sides getting together and talking about the case each month over a debt that's $1,300, and suddenly like you're spending more every month on attorney fees than you are on the debt. So usually everybody is happier if we just set a sum certain for the amount and everybody goes on their not so merry, but at least, you know, on their way. It's interesting to me that these are still relatively uncommon cases. My best guess for why that is that most of us in the immigration law community, we're focused on helping people get immigration benefits, right? And rightly so. Our focus is fighting the mean federal government for our deserving, cool clients. And that's really our focus. And we don't think about knocking heads with other attorneys and private parties to recover damages. It's somehow just like not our mindset within our community, which is largely great. But it leads to, I think, this type of civil claim just not really being on people's radar in a very robust way. I guess an ask that I would have for you all going away from the talk today is like, just have it on your radar. You don't have to do these cases if you don't want, but if you've got that client like Anna coming in the door, who's got the I-751 petition and is broke, tell her she's got a potential claim under the Affidavit of Support and she should look into it because that's important. It's important for her. I'll get on my soapbox in just a minute on that regard. And also conversely, in like the civil litigation context, almost the only family law attorneys I have ever spoken to who knew anything about this, it was only because they had gone through the immigration process themselves for a former spouse. So the only reason it was on their radar is sometime in the process of doing their husband's paperwork, they got the Affidavit of Support and said, whoa, what is that? But aside from that, family law attorneys just aren't advising their clients about this. And I bet you dollars to donuts, there is going to be a malpractice suit against a family law attorney in the next 5 years because of that. Talked to a former family law attorney of one of my clients a couple of weeks ago, and he might be a good candidate for this. Because I mean, come on, like it's like the Padilla thing in the criminal context. Like, I understand family law attorneys aren't immigration experts, but there are things that you do need to be aware of because they will come up for your clients. So tell your family law attorney friends to get savvy about this. So in terms of who the likely plaintiffs are in these, you know, obviously there are all sorts of people who end up being in residential status and being low income. A greatly disproportionate percentage of the plaintiffs I represent are domestic violence survivors who are suing their abuser spouse. Because if you think about it, I mean, it's like the most vulnerable population you can possibly imagine. You've got foreign national coming to the US, oftentimes limited language experience, often massive power disparities. If you think about, you know, kind of squirrely K1 contexts, if there are other fans of 90 Day Fiancé out there, you know what I'm talking about. If you don't know this from your own practice, you know, there are bad situations out there where K1 comes over, the situation is way different than they thought it was going to be. They, you know, often through incredible courage, manage to separate from their abuser in a country where they know nothing about, you know, just basically getting by. And because of that legislation in 1996, they don't get means-tested public benefits. So they have no lifeline except for the Affidavit of Support. A client who I was working on today, she was in a DV shelter here in Tacoma, Washington, and she had nothing. You know, she had the bag of stuff she was able to gather when she ran out of the house and left her former husband. Doesn't qualify for much in the way of public benefits, and this is like the thing that she has to rely on. So I get it that some AILA members are pissed off about their sponsor clients getting sued. I'm sorry. I'm pissed off about my client having been subjected to horrible abuse from her petitioner. And we are going to win in federal court, and he is going to lose. And by my lights, that's an okay resolution of that situation. Okay, this is more from a perspective of family law attorneys, but my ask for all of you, I'm going away from this, is just have this on your radar. If you guys run up to issues in this, like you talk to somebody and you don't know if they have a potential case, or they have a potential case and they want to know what their options are, like, just call me. I'm happy to talk to you about it. I won't charge colleagues for talking about this sort of stuff. I'm more than happy to kick the can around and see if your client or prospective client has a potential case.